This is SJC-13238, Lory-San Clark, and others v. Attorney General.
Okay, Attorney Hewer.
Chief Justice Budd, and may it please the court, Tad Hewer on behalf of the plaintiffs. With me virtually are Andrew London and Seth Reiner. This petition fails to demonstrate operational relatedness for at least three reasons. First, the Section 3 annual reports are not operationally related to implementing the Section 2 medical loss ratio, the MLR, much less to regulating dental insurance rates, which is the Attorney General's proposed common purpose. These reports require additional data beyond that in Section 2 that's unnecessary for verifying an MLR. They require extensive entity-wide insurance data that goes well beyond just dental insurance. They contain no mechanism by which the Division of Insurance, the DOI, could use backward-looking historical data to regulate forward-looking rates. And they even require extensive data to be reported by self-insured groups, which are groups to which the Attorney General admits in her brief that the MLR doesn't even apply. It's very difficult to conceive of a situation where two elements are related, where one provision, the reporting, doesn't apply to the second provision, the MLR, particularly for these self-insured groups. Now, the Attorney General calls.
So can you address the issue of the Attorney General's response that you're narrowly focused on the MLR and Section 2 actually is much broader than that?
Sure. The MLR is one element of Section 2. I would say that narrow focusing isn't the test that this court applies. We apply operational relatedness, not narrowness.
No, the accusation is you're narrowly focusing on MLR. I know that's the title, but could you address the argument that Section 2 is much more than MLR?
It may be much more than MLR, but it's not significantly more than MLR, and it's not about rates, right? And that's the distinction here. Even the petitioner doesn't believe this section is about rates. They say it's about how much of a premium is going to be used towards paying for dental costs. Are there other elements in here? We have MLR, we have administrative load, and we have contribution to surplus. All of those are percentages of how much your rate is being expended. So your rate could be $5, $15, $50. All that Section 2 says is what percentage of that has to go towards each of these components. It doesn't regulate the rate. That would say there's a rate cap or a rate floor or something else along those lines. But even if Section 2 does regulate rates, as the Attorney General suggests, and even if it's broader than just an MLR, Section 3 doesn't have any relationship to those Section 2 rate settings. We know this for a couple of reasons. One is that it requires significantly more information, right? So, and it's on an entity-wide basis, which again is important. So it's very difficult to understand, for instance, how knowing information about the number of life insurance beneficiaries an insurer has, or the claim operating expenses for its disability insurance line, for instance, would help the Division of Insurance determine whether a dental rate is excessive or not. It almost can't. More to the point, in Oberle's, this court rejected that argument, right? This court said that shining the light on something, that was the argument that the petitioners made there. They said they're all connected on patient safety grounds, but it helps shine the light to have this additional financial information.
But Oberle's was a case in which that was the nursing ratio case, is that right?
That's correct, Your Honor.
So there we've got nursing ratios and then all this financial data about hospitals. Here, at least it's a rate overview provision, right? I mean, there's some relation. It may be too tangential, but there is some relationship, isn't there? It's different than Oberle's.
It's not different from Oberle's, we don't think, because Oberle's agreed that there was a marginal relationship. That's the term the court used. But that wasn't sufficient for Oberle's to find that there was operational relatedness in order to save the petition.
Well, wasn't the issue in Oberle's that the hospital was going to have to implement the ratios no matter what their financial status was? And the distinction in this case is overhead has something to do with rate setting and premiums charged, correct?
No, Your Honor. As I just noted, Certain of the entities, the self-insured entities, don't have to comply with the MLR. It's not obligated. We know that from Section 4, they're exempt. So they'd be making reporting just for reporting's sake. It would have no relation to the rate because they're not subject to the MLR rate. That's a key distinction. Another distinction is that here.
I'm sorry to interrupt your argument also, but are those entities subject to the commissioner's disapproval of any proposed rate changes that are excessive, inadequate, or unreasonable under
No,
Section
because
2C? Yeah.
No, because Section 4 of the petition expressly exempts them. All right, so if you go all the way to the end, Section 4 says, except as otherwise provided below, this chapter shall not apply to dental benefit plans insured, delivered, or renewed to a self-insured group. Right, so Section 4 clears the field. We pointed out that strangely, Section 3 doesn't. So there's a provision in Section 3, that's Section 3C, that applies to self-insured groups. We've said that is facially internally inconsistent, but that's not the point. The point is that they're exempted from Section 2.
Where are you reading in Section 4 that it doesn't apply to these self-insured groups?
Second line, not Section 4 of the petition.
Okay.
That's the except otherwise. Look at Joint Appendix 28. It would be
So
Section 4 of the proposed law.
Okay, thank you.
Section 4 of the proposed law expressly says this chapter shall not apply to dental benefit plans issued, delivered, or renewed to a self-insured group.
Okay, thank you.
Additionally, when we're talking about Oberle's and whether Oberle's has this mandate or not, the MLR is mandated for anyone to whom it applies. You must comply with the MLR regardless of your reporting obligation. Simply remaking your report here doesn't excuse you from the MLR. Saying I've got a lot of financial difficulties as shown in this report doesn't mean you don't need to produce an 83% MLR. What Oberle said is that if you have a situation where they are an inflexible mandate, right? So you have a situation in which you aren't allowed to say, on one hand, I have an MLR, but I don't need to comply with it because of my financial obligation. That's related only at this marginal level. And that's what Oberle said was impermissible. Not something that they said was permissible.
Mr. Hewitt, I may have missed it, but go back to your other argument. Are self-insured subject to the financial disclosures? I thought they were just exempted from everything, but they have to comply, in your view, with the financial disclosure?
Not in my view, but in the petition's view. Let's look at Joint Appendix 27, Section 3C.
The sarcasm is great, but you just answer my question.
The Section 3C.
Right.
So Section 3C says,
do self-insurers have to comply with the financial disclosures?
Yes, they do. Section 3C says any carrier required to report under the section, which provides administrative services to one or more self-insured groups, shall include, as an appendix to report, the following information, including sub 5, Roman B, information for all the carrier's self-insured customers, sub 8, the percentage of the carrier's self-insured customers that include each of the benefits, and sub 10, administrative service fees paid by each of the carrier's self-insured customers. Section 3 clearly says that self-insured customers are reporting under Section 3, but as we know from Section 4, they don't have an obligation to produce an MLR of 83% under Section 2. They would be reporting without having any relationship to the MLR that's created in Section 2. If the petition has to be related, then those two provisions have to be related. And by definition, they're not. In addition, we know that the Attorney General here and the proponents are having some difficulty in identifying a common purpose that accurately describes what at core is only a 2-section petition and isn't too abstract. And we know that this notion of abstraction is important for relatedness because you can't have elements related only at too high of a level of abstraction. That's Carney. And in Anderson, this court described the difficulty in articulating a purported common purpose as telling and not in a good way. And it's telling here as well. When we talk about regulation of dental insurance rates, that's the Attorney General's proposal. That's both inaccurate, as we've noted before, because we don't believe it applies to rates. And quite frankly, nor do the petitioners. They say it's about a medical loss ratio, not the amount of money that's being spent, capped, floored. And it also doesn't go to Section 3 because Section 3 doesn't have any implication for how you set your rate. We know from Section 3 that you're just providing additional information. You're just telling you how much information, how much you're spending on certain elements, how many members you have in your plans, but it doesn't provide the Division of Insurance with any authority whatsoever to use that information to set a rate or to change a rate or to modify a rate. All they can do is
Or
issue
even disapprove of a rate change?
or disapprove of a rate.
So
we
explain
also-
that last part. How
So
is the financial disclosure not helpful in determining whether to disapprove of a rate under Section 2C of the petition?
it's useful. So there is a financial disclosure provision in Section 2. We know that Section 2 has a whole range of things that the Division of Insurance is able to use to verify or calculate whether these MLRs that are being submitted. And again, in Section 2, we know that you need to submit your current and your projected MLR. So that information is at the division. And the division uses the information in Section 2 to have a discussion with itself about whether that
So
rate.
I'm sorry to interrupt you, but just to cut to the chase. So you're saying that Section 3 of the initiative requires additional disclosures over those of Section 2, and that those additional disclosures are not helpful at all in approval or disapproval of rate changes.
It's not they're helpful, it's that they're entirely unrelated. And we know that because it's requiring it on an entity-wide basis. So if you are a insurer that offers disability, life,
So
and
are
dental,
you saying they're helpful? Are you conceding they're helpful?
they're helpful only to the extent that that's what's required in Section 2. We know from Section 2 that that's
No. So let's stop. The additional disclosures required under Section 3, are they helpful
I don't
in
think.
determining whether to approve or disapprove the rate changes?
No, because they're backward looking, right? Section 3 requires reporting historical data, what you had the previous year. Section 2 is about your current and proposed MLR. That's going forward. And we know that if you have, for instance, let's say 2023, the first year, you'll report your current MLR and your proposed MLR for 2024. In 2024, you'll present your current MLR for 2024 and your proposed MLR for 2025, right?
So your position is that it's not helpful to get backward-looking financial data if let's say the commissioner needs to approve the adequacy, appropriateness of the rate change. So it seems to me that might not actually, as a matter of logic, work. Isn't it important to know where you've been, where you are, and where you're going in order to figure out the rate, whether the rate change is appropriate?
Excessive or unreasonable?
Yes, exactly. The language from the initiative. Thank you.
No, because again, you're looking at backward-looking data that can't inform your future rate. There's no way to say in 2024 that you'll be able to use that data that you will have from 2022 to determine whether your 2024 rate is reasonable. That's what Section 2 does. It asks for all that information precisely to allow the commissioner to make that determination. But the other thing you don't need is the information about your disability line, your vision line, your life insurance line to inform whether an excessive rate on the dental side is excessive or not. You could have significant amounts of information that are entirely unrelated to the dental provisions of Section 2. Section 2 only relates to dental. Section 3 asks for entity-wide information from the insurers across their entire insurance line. That's everything they insure. There's hard to say that that has a relationship beyond any marginal relationship or minimal relationship to what the insurer is allowed to provide or what the dental insurance plan needs, the Division of Insurance needs to determine a Section 2 MLR.
Even though these overhead costs could be spread across the different lines.
It's not quite clear how that would work. So first of all,
Yeah, it's not clear to me. That's why I'm asking the question. But that
I mean,
was the response I think that the AG gave.
It is, and it sounds ominous, of course, right? It sounds like it's concerning, but I think we need to look at two things. The first is it's not evident it's even permissible, consistent with the carrier's fiduciary duties, to say that you can take risk-based capital or other elements that were collected for one more riskier line and then subsidize a dental line with them. That may not even be permissible. But second, even if it's permissible, and let's say for the sake of argument it is, nothing in the petition indicates that that constitutes a violation of Section 2. Section 2 says we want you to reach an 83% MLR, one way or the other. We know that a petition can address foreseeable consequences. That's Hensley and that's Wiener, but it doesn't allow any potential hypothetical future consequence to establish relatedness. That would vitiate the relatedness requirement. So here, let's look at the two possibilities that would be suggested. One is that you have an insurer that is over the 83% dental MLR. The concern seems to be that they move administrative expenses from other lines into the dental line so as to reduce the MLR. But the plan in that situation would still meet 83%. That's what the petition wants to happen. The other alternative is that you move your administrative expenses from the dental line out to other lines, right? So as again, bring your MLR, which may be below 83%, up to 83%. But that means that those costs aren't being borne by your dental beneficiaries, which again is what the petitioners want. So regardless, you're in compliance. I think the sum is how the insurers get there is not operational related to their obligation to get there.
Okay, thank you very much.
Thank you, Your Honor.
Attorney Hornstein.
Good morning, and may it please the court. Adam Hornstein. I'm an assistant attorney general. My pronouns are he, him, his. And together with Ann Sturman and Michael McKenzie, I'm here today on behalf of the defendants. I would like to begin by answering Justice Wendelant's question and picking up on her colloquy with plaintiff's counsel. And I'd like to begin by telling you 3 ways in which Section 3 and its reporting obligations and its enforcement mechanisms are not just helpful, but are related to what is happening in Section 2 of the petition and with the Attorney General's proffered unified statement of public purpose. First, let me pick up with the idea of accounting chicanery. This is the idea that Section 3, which contemplates entity-wide reporting, in other words, from each line of an insurance carrier's business, by inquiring insurance companies to report on a line-by-line basis what their various business lines do, it prevents them from shuffling overhead expenses from, say, disability insurance or life insurance from dental insurance to disability or life insurance in a way that would inflate other overhead expense lines while simultaneously decreasing the overhead expenses shown in dental insurance. And as plaintiff's counsel acknowledges, this is a way in which the petition addresses potential knock-on effects of Section 2 with not just medical loss ratio, but its other 2 yardsticks.
But doesn't Section 2 set up a process and a formula for preventing abuse in the dental insurance line? So isn't it self-enforcing? What difference does it make if there's something going on in another totally unrelated, potentially, a market that's much tougher and, everything else, if Section 2 does the work for it?
Well, Section 2 does a lot of the work, Your Honor, but it doesn't necessarily do all of the work. The fear here, as we apprehend it from the petition's language, is that let's suppose a situation in which there is a salesperson who works both in dental insurance and life insurance. How are the Section 2 reports going to capture what portion of that salary is attributable to dental insurance versus life insurance unless the fuller picture is disclosed to the commission? So that is how it attempts to address that concern. But even leaving that aside, there are still two other ways that Section 3 ties back to Section 2. One is actually flagged by the amici's brief, which was filed after the red brief. This is the idea that the Section 3 reports can be used to evaluate the overall financial health and liquidity of a dental insurance carrier. And you'll realize that Section 2D of the proposed law contemplates that the commissioner can give a waiver to the medical loss requirement if it would result in substantial financial impairment to the carrier. Again, the reports in Section 3 make patent what an insurer's overall financial health is. And indeed, the CMR provisions
But
cited
again, like in Oberle's, you know, the ratios were going to happen anyway, but the argument was made, look, you know, this is going to be fought out hard, so we're going to have to show that the hospitals have plenty of money. And we still said that wasn't enough. And let me give you another case that I actually think maybe even more on point is Gray, because, you know, the curriculum was analyzed, but then we didn't allow, you know, standardized test results, which, you know, I'm not sure Gray is hard to interpret, but I don't see how you can square your case with Gray.
Well, let me attempt Oberle's first, and then we'll turn to Gray. In Oberle's, the proposed law was rejected because the nursing staffing ratios were, as the court observed, quote, mandatory and inflexible. But Section 2D of this proposed law makes clear that medical loss ratio is neither mandatory nor inflexible. It is one, just a presumptive yardstick, but two, 2D contains a waiver provision that permits the Division of Insurance to waive medical loss ratio requirements under certain circumstances. And those circumstances would be illuminated by the reports contemplated by both Sections 2 and Section 3. Gray, I fully recognize, is a more challenging case. And there, let me make two distinctions. One, whereas the Common Core reform portion of Gray was unmoored from just general notions of financial transparency promoted by promoted by disclosing prior year's test questions. That is not the case here. As I think plaintiff's counsel admitted and then walked back, the Section 3 financial reports are helpful in making the Section 2 determination, but Section 3 itself has its own mechanism for encouraging insurers to reduce the cost of their plans or for improving patient care. This is in Section 3E of the proposed law. It contemplates that carriers who have too much surplus as measured by the risk-based capital ratio are required to tell the Division of Insurance how they're going to, again, reduce the cost of their plans or improve patient care. Again, this is a direct link to what this proposed law is all about. And that's creating this scheme to comprehensively regulate dental insurance rates that are excessive.
So how about the self-insurers then? What's the point about the self-insurers? Why are they in the mix?
Terrific question, Your Honor. I have two responses to plaintiff's counsel's discussion of the self-insured issue. Section 4 of the proposed law certainly exempts them from Section 2 of the proposed law. That is as plain as day. But what Section 3C of the proposed law says is that these self-insured plans also need to make entity-wide reports. And they too are subject to the Section 3D direct regulation mechanism that, again, makes carriers, including self-insured plans, dedicate excess surplus to reducing costs or improving patient care. So even the self-insured plans are subject to what my office has identified as the unified statement of public policy here. Though they may be exempt from Section 2, self-insured plans.
So explain as a practice. So I thought again, and I don't fully understand this yet, so I don't mean to load the question, but I thought that the division can't do anything with this Section 3 information to the self-insureds. So they're collecting it, but they can't use it in any way to, am I wrong on that?
I don't think you're wrong about that with respect to section 2, Your Honor. So the division wouldn't be doing anything with that information with respect to section 2 qua section 2. But, and this is the critical point overlooked by plaintiffs here, is that the self-insured plans still need to make the reporting under section 3A and 3C. And that information in turn can be used by the division in section 3E to make self-insured companies submit testimony on their financial status and the need for a large surplus, and to make public findings in light of this testimony about how the carrier, including self-insured carriers, can dedicate this excess surplus to reducing the cost of their plans or for improving patient care. This is 3E.
But they can't do anything. They can shame them, but they can't do, they can have a public beating, but they can't do anything with the information. Is that right?
Well, so there is the public hearing. I wouldn't call it shaming. I mean, it's not just a public hearing for the sake of a public hearing, Your Honor. It is a public.
What is it?
It's a public hearing in which a carrier would be required to give testimony as to ways in which it can improve patient care or can reduce costs. And then the division is empowered to make findings about that. I'd like to think that as a government employee, when the government speaks and makes findings, it's not just a tree falling in the wood that doesn't make a sound, that it has some real tangible impact in a way that
usually there is some real tangible impact, as opposed to, berating and criticizing without doing anything. I'm not sure I know other examples. I'm sure there are other examples of this, but it's a little odd that you don't do anything with the information that you collect.
Again,
besides, surface it.
It's not doing nothing. Again, there's the hearing mechanism, there's the public findings mechanism. So I wouldn't say it's doing nothing. But even still, it's the whole thrust of this ties back to the public policy point, which is that it relates to the regulation of dental insurance rates in relation to benefits furnished to policyholders. That's what that mechanism is all about. It may not be as strong as the court prefers, but that just is a matter of scope. It's a matter of drafting, and the petitioners enjoyed some.
But again, can I just follow up? So they run a sloppy life insurance business. Why is that part of this dental business inquiry? Because these insurance companies can be massive, right? They can have 20 lines of insurance and they're going to report on 19 of them because the dentist issue requires more supervision. I mean, I get section 2 and I even get section 3 of it. We're confined to dentist stuff, but once it starts getting into huge reporting requirements on all these other lines of insurance, and by the way, that the legislature is just rejected in the medical context, doesn't it sound like it's unrelated?
Respectfully, Your Honor, again, this goes to the scope of the petition. The petitioners are allowed to essentially reenact laws that were repealed by the legislature. This is one way in which the drafters of this proposed law saw fit to mitigate or to address a potential consequence of what's going on in section 2. That it could be stronger, that it could be different. These are all points that plaintiff makes, but that is not dispositive on the relatedness issue. It just needs to be operationally related, which the Attorney General submits that it is. Unless the court has any further questions, I'm sure that Mr. Perry can adequately address anything that I have missed, and I thank you for your time and I urge you to affirm the Attorney General's certification here.
Okay, thank you. Attorney Perry.
Thank you, Madam Chief Justice. Good morning. May it please the court, Matthew Perry on behalf of the interveners. I'd like to respectfully just submit a couple key considerations for the court. First, it is true, as appellant's counsel has noted, that the Attorney General and the interveners have described two different common purposes for the initiative. But rather than showing some sort of discord or disparity, the fact that these two bases exist shows that the initiative's parts are so interrelated that it passes the relatedness test in at least two ways. Or in other words, there are at least two common threads running throughout the initiative that pass the relatedness test. Despite this, the appellants have, for the most part, only attacked the Attorney General's relatedness requirements by claiming that certain data cannot be used in the rate-making process. Even if that were true, and even if that were actually problematic for the Attorney General, which I don't believe it is, the appellant's claim does not undermine the relatedness described by the interveners, which is that all parts of the initiative are intended to ensure that an adequate amount of dental premiums are spent on patient care. There's been no meaningful attack on this purpose, as it doesn't even mention rate making. Second, the data in Section 3 can be used to help verify the accuracy of carriers' MLRs. The appellants have apparently conceded in their reply brief, at least, that carriers could utilize financial accounting practices in order to manipulate the MLR. So just as it was conceivable in the Wiener case that lifting restrictions on alcohol sales could lead to increased sales to minors, it is also conceivable here that implementing a new financial restriction on carriers could lead to financial manipulation. Finally, I would just like to briefly address Justice Kafker's comment about how the public beating that is required under Section 3 for self-insured carriers. It's more than just, as one would say, a public beating. What it actually does, and if you look at the language closely, it mandates the insurers to come up with a plan as to how to reduce costs or increase the improvements of quality care. So this mandate for self-insured carriers, I want to also be clear here that—
So how does that mandate work? So you go to the hearing and one of the self-insurers is running it poorly or whatever. What happens? What is the mandate? They have to fix themselves, or does the AG or somebody have the ability to mandate anything? I like the word mandate. What's the mandate?
So the mandate is in the form of testimony that indicates that the carrier will, not merely can, but will use any certain amount of excess capital beyond the 700% risk-based capital that will go either towards patient care or toward improving the quality of care. It does not mandate in the sense that—
So it mandates testimony that's going to result in perjury violation? I'm confused. What happens to that testimony?
Well, yes, Your Honor. Theoretically, that could be grounds for perjury. And while certainly there is a question— I get it.
Can I shift you for a second? So, initiatives, we want the public, the public has a limited capacity to, time and energy to focus on these things. So we want sort of rifle shots that they can understand. I don't understand all of the, I get there's something very useful about requiring insurance companies to produce all of their financial data. That's useful, but I also don't understand, that seems to me a very different proposition than monitoring dental rates. To me, those are separate enough that that a voter may have different views on that, particularly when it costs money. If the insurance companies have to spend a lot of money generating this data, it gets passed on to somebody. They don't eat the cost themselves. So are we really asking voters to vote on a unified, related proposal, or are we asking them on two potentially good ideas, but separate?
Respectfully, Your Honor, I believe this is a unified idea. With respect to the fact that carriers have to report across various lines of business, this goes to the issue of the carrier's solvency, right? And so as the appellants have tried to suggest, the medical loss ratio is going to have some sort of financial impact on carriers, right? And they have even suggested that this may lead to insolvency, right? So it is untenable to assert on the one hand that these medical loss ratios are going to bankrupt carriers, but on the other hand, that the commissioner cannot monitor that for various purposes under the petition, which includes, as Attorney Hornstein mentioned, the waiver requirement under Section 2D that allows the commissioner to waive the rebate requirement if carriers are financially impaired. One way you can determine financial impairment would be through looking through the solvency metrics across all lines of business. The second piece of it with respect to the cost involved with regards to the reporting of these metrics, that may go to some degree of burden with respect to Section 3, but it does not go to the issue of relatedness. And I would just briefly note, the amicus brief has suggested that the insurance carriers are already required to report much or all of these same metrics for an entirely different statute. Ironically, they suggest that therefore this would make it burdensome, but in actuality, it would not be burdensome because assuming they're correct and they already report these metrics for another statute, they can just simply cull that data into this report under Section 3.